I'm going to, when I flip over to the session, quickly, and I mean very quickly, burn through some of the things that we covered yesterday, which are some things about ACSESS and CPC, but these are covered at the beginning of every module. And since we did it yesterday, we don't really need to do it again, but I will, because this session is being recorded and someone might come in after to listen to it. I'm going to just talk real fast about it. Okay, so again, welcome and congratulations on making the decision to take your CPC, Certified Personnel Consultant, offered by ACSESS, the only certifying body offering third-party recruitment training in Canada. The Certified Personnel Consultant certification comes with 5 courses in legal aspects of staffing, which we did yesterday, legal aspects of recruitment, which we're doing today, which are more generic about some high-level principles in recruiting, law, in recruitment law. There's a health and safety section, a recruitment section, and business practices and ethics section. We do have a challenge exam that will take place after those 5 sessions. It's 60 multiple choice questions, and you will receive a link to do that online exam at your convenience once you have qualified by completing all 5 of the sessions. As mentioned in previous sessions, ACSESS has a mission statement, which is to basically protect and represent the industry, to communicate with all levels of government, our customers, the business community, and our applicant community in order to improve and protect and promote our credibility and visibility, and also to provide members with member services much like this, or safety group and other services that are very, very valuable to members. When we do the workplace health and safety session, we'll talk to you a little bit about safety group, which is probably, I think, the 4 main reasons why people join ACSESS is to get their CPC, because of business ethics, because of government representation for us in legislation, and because of safety group. And safety group is huge, and organizations that participate in safety group over the years have qualified for significant rebates, and it's been a wonderful program. When organizational companies become members of ACSESS, they make a commitment to uphold our code of ethics and standards, and we ask every member company to prominently display the ACSESS code of ethics in their offices and where they can on their websites and in other places for people to understand the principles that we stand for. Today, we're going to talk a lot about human rights and the various forms of discrimination, how it affects our hiring practices and our business practices. We're going to look at other things, the different types of discrimination that can occur. We're going to talk about diversity, equity, and employment equity, and understanding the differences in those concepts and laws. And we're going to talk about personal privacy legislation. And of course, we're going to commit to uphold the legal aspects of recruitment and selection as CPC members and ACSESS members. So in a big picture, for just reviewing today, we're going to be talking about human rights acts and laws. We'll delve into employment equity principles and the Federal Employment Equity Act. We're going to talk about diversity and equity and some of the other bits of legislation and how it affects our business, and how we can use the effective understanding of diversity and equity to promote our business. And we're going to talk about privacy and how it affects us. So first off, from human rights. I mean, human rights really is a principle that describes how we instinctively expect to be treated by others, and in return, how we will treat them. And this is, some of it is not only just instinctively an understanding of how we think others should be treated and how we would like to be treated, but we now sort of look at human rights legislation, and so it becomes an entitlement. And it becomes an entitlement to treat people with dignity, with respect, and with equality. Now, it doesn't mean that all people are equal, and it doesn't mean that all people should be treated exactly the same. It means equality means that people have the same opportunity, that we work with the same standards, that they're defined standards. And so we'll come back in various parts of the legislation to understand the subtleties of equality. With respect to human rights, what we talked about yesterday in the different parts or aspects of law, where we've got constitutional law and statute law and common law and contract law, we have got one of, and we talked about the designation or delegation of authority between provincial and federal authorities. It's important to understand that many of the principles of human rights are in the federal legislation, in the Charter of Rights and Freedoms, and in the Constitution. And the Constitution will divide that legislation between those that are federally regulated and those are provincially regulated. So we have got federal legislation, the Human Rights Act, the Federal of Canada, that applies to all federally regulated industries. And we talked about those yesterday: fisheries, oceans, telecommunications, airlines, ports, you know, the, I can't even remember, interprovincial trucking and rail. So we talked, and obviously federal crown corporations, they must all apply to the federal legislation, and provincially, all the rest of us must comply with the provincial legislation. So we've got the Canadian Human Rights Act, which is that federal act that we talked about. We've got the Charter of Rights and Freedoms, the Charter, which falls part of the Canadian Constitution, which drives, remember we talked about the Charter of Rights and Freedoms and the Canadian Constitution being the law of laws, giving guidance to all laws about who has the authority to make the laws, in what jurisdictions those laws have, and what principles those laws must uphold. So that's what the Canadian Charter of Rights and Freedoms does for us. And we've then got our provincial legislation in Ontario. It's called the Ontario Human Rights Code. And again, you're going to hear it sometimes referred to as an act or a code. Don't be confused by those. I have never quite figured out. I've never quite figured out why, there is no difference legally between an act and a code. They're all passed through the legislature and the House of Commons in exactly the same way. I think it's just the name that they choose to give them at the time that they're passed. Human rights legislation applies to all of the following practices, and sometimes more, but recruitment advertising, referrals of candidates, promotions and demotions within a company, training and training opportunity, wages, how much people are paid and how they are paid, our application forms and the questions that we ask are all covered under human rights legislation. The interviews that we perform and the questions that we ask are all, now the legislation doesn't tell you the questions you can or cannot ask. It tells you about the areas of things that you cannot ask about or consider in making your decisions. It applies to apprenticeships, who qualifies and doesn't qualify for apprenticeships and the opportunities that are provided to different people. It applies to transfers inside companies and all other matters relating to employment or possibility of prospective employment. Discrimination is an action or a decision that treats a specific and individual person or a group of people negatively for reasons such as their race, age, or disability. And we'll go over the in the next screen, I think, the what are called grounds of discrimination. There are 11 grounds that are protected under the Canadian Human Rights Act. Now, the Canadian Human Rights Act, again, we're going to talk a lot about it because each of the provincial legislations in the various provinces and territories really are quite similar in and apply to the exact same principles as the Canadian Human Rights Act. And in fact, decisions, so each of the individual provincial legislations are trying to, in the provinces, each province's own way, address the Charter of Rights and Freedoms, and to emulate or simulate the Canadian Rights Act. And so they use different language and they enforce it differently, and they have different kinds of penalties and different names for the organizations that enforce it. But at the end of the day, it's all pretty much the same. And in fact, a decision on a human rights issue can be made in a court like a British Columbia provincial court, and is likely to have impact in all of the other provinces and the federally regulated industries in Canada, because it's Canada, because they're all based upon exactly the same principles, sometimes just worded differently. And I'm going to give you a good example of that in a little while, when it comes to LGBTQI section of human rights. So the areas of discrimination, the 11 areas, are race, national or ethnic origin, and color. Now, I'm not an expert in understanding the differences between race, national or ethnic origin, and color. I think, sometimes one implies some of the other, and sometimes they're not the same. But between those three sections, they all are kind of intermingled together. There's a number of religion, age. There are some limits to age. There are some reasons. For example, just recently, the Ontario courts decided that the age of 65 was a reasonable age to start to disqualify people from certain corporate benefits. That as long as you tell them in advance, this is only going to last you up to age 65, that the courts agreed that that's a reasonable date, because let's say it's life insurance, and it's term life insurance. If you didn't have an age on it, then everybody would eventually get paid out on life insurance, and life insurance companies would go bankrupt. So, so they decided recently that 65 was a reasonable age, because I think it always was 65 for a lot of aspects of benefits. Some benefits can go longer. You can purchase them to go longer. But I think somebody tested it, it was ending, and they lost. On sex, sexual orientation, marital status, family status. So again, we start to get into marital status and family status are sometimes the same, sometimes they're different. They're definitely intertwined with each other. Disability is also an area of prohibited grounds. And we'll talk a little bit about, I'm not going to beat it to death on convictions. Decisions in hiring can absolutely be made based upon a person's previous criminal history, so long as they have not been granted a pardon or have their record suspended. So when an individual is granted a pardon or their record has suspended, that's sort of the legal way of saying, okay, you've done your time, you've paid your dues, enough time has gone by, you haven't ever recommitted to crime, 25, 35, 50 years have passed. We're going to pardon you, or your record has suspended or expired. and people should not be allowed to use that information anymore because it is now irrelevant in your hiring. Now, this particular case that I talked to you about with LGBTI um, uh, legislation is a great example of how the legislation is created. Now, we talked the other day about common law, and we talked a lot yesterday about common law and how very often, and particularly in the province of Ontario, and with respect to temporary staffing companies and employment agencies, they're tending to codify or put into a statute a change in law that goes through the legislature and through all of the readings and becomes a law based upon some of the decisions that have been made in common law and in previous court decisions over common law. And so, interestingly enough, the issue of sexual orientation was not included in the Canadian Constitution and in the Charter of Rights and Freedoms. And then in 1995, in a court case called Egan, the Supreme Court of Canada decided that although sexual orientation is not listed in the grounds for discrimination in the charter, it did constitute an equivalent ground. And so our then current understanding in 1995 was that, if we take a look at the meanings of gender, then we can expand that to include LGBTI, and it became an area, prohibited grounds for discrimination. And then another case in 1998, Vrend in Alberta. Now you'll notice that the first case was a Supreme Court of Canada case, and the Vrend case was an Alberta provincial case. But because it has to deal with the issue of human rights and it is a federal standard, cases in other provinces can find their way across the country to influence the decisions of other courts and legislatures across the country. So in Vrend versus Alberta, the court held that the provincial human rights legislation that left out grounds of sexual orientation also violated section 15.1 of the Canadian Constitution or of the Charter. And so now we've got two court cases, one provincially and one federally, pretty close together, saying, hey, sexual orientation is really the same as gender and marital status and family status. I said these are kind of all intermingled. And so in 2000, the federal government passed Bill C-23, basically saying, yeah, this has been decided in common law and in civil law. It's been decided, so let's write it into the statute. And so in 2000, Parliament passed Bill C-23, which gave same-sex couples the same social and tax benefits as heterosexuals in common law relationships. So, but there was also right around that time, and I don't know the year, I know the lawyer, Douglas Elliott, went to the Supreme Court of Canada, and he was over CPP death benefits for same sex couples. I don't really know a lot about CPP death benefits, but I think it's kind of like if you're collecting CPP and you qualified for CPP and you're married and you die, you're no longer going to get the CPC, but your spouse gets like a $5,000 one-time CPP death benefit. It's kind of like saying, okay, this will recognize the fact that they still had some money in the pot. Don't take me verbatim on the number, but there's what's called a CPP, Canada Pension Plan death benefit that goes. And so that case was also won right around the same time. And so Parliament basically said, hey, same-sex couples are entitled to all the same social benefits, which included the tax benefits of marital status, the tax benefits of them having children together, the CPP benefit for the death benefit for married couples. The enactment of the Civil Merit Act in 2005, so shortly thereafter, marked a milestone in sexual orientation equality rights, allowing same-sex couples to be married anywhere in Canada. So it's interesting because even though the common law was saying, hey, and the court decisions were saying, hey, we recognize this, it still always feels a little bit ambiguous that different cases and different circumstances might be decided differently by different courts. And so that the way that our governments go about making our laws is they very often take those court decisions and they come back and say, we're going to do two things. We're going to say, one, same-sex couples will have the same social benefits and tax benefits. And number two, we're going to allow them to legally marry and get a marriage certificate to kind of nail down the fact that they are in fact married. So that's kind of how the laws are created and how that one particular aspect of our laws changed after the Canadian Constitution and the Charter of Rights and Freedom was written. So we're now going to talk about this thing which you don't hear so much about. We hear about systemic discrimination, which we'll talk about next. But first, we're going to talk about adverse effect discrimination. Adverse effect discrimination is when a company or an organization has a policy that sometimes, when it's put into practice, can unintentionally single out a person or a small group of people or a particular group of people, and as a result of that, give them unfair or unequal treatment. So this is unintentional and unwitting discrimination, and we call it adverse effect discrimination. So all discrimination is bad. There's no doubt about that. But this is not as bad because there's remedies to this. Once we understand it exists, there's remedies to it, and we'll talk a little bit about how that works. So some examples of adverse effect discrimination would be requiring an employee to wear a uniform, a promotional uniform, that conflicts with a person's religious clothing requirements. So head coverings is a really good example, and different religions have different approaches to head coverings. And we're going to talk to you probably, I think later on, about a case, probably RCMP, and another case about hard hats, about head coverings that didn't fit well into the individual complainant's religious beliefs. Establishing a work schedule that uniformly rotates. So, you do mornings, afternoons, weekends, you do these 4 days of the week, and then you do next week, you do those 4 days of the week, and the next one you do. And, there's all kinds of factories and organizations, hospitals, healthcare facilities have got these rotating shifts, and they try to rotate them fairly and uniformly. However, some people can't work on certain religious days. And so having a policy or standardizing office furniture is the final example on this page, where the specifications create consistency and brand and look, and it treats everyone equally. We all get the same cheap laminate desk, and we all get the same crappy chair, except for when a person has a disability and that doesn't work for them. And so having a good policy that might save the company money, or might be great for promotion, or might seem really fair to people by rotating shifts around, can sometimes adversely affect individuals who maybe can't come to work at all, or can't come to work on a particular day and lose income because of their religious beliefs. And so there's lots of other examples. Now, systemic discrimination is the one that you hear this word used and often pronounced improperly. Systemic discrimination is the one that we hear about that is not very good. So this is when discrimination happens because of business practice or workplace policy or a government program or something in place will it's not limited to a single circumstance, and that the recurrence of the systematic process, this set of policies and practices that are in place, can consistently affect a large number of people, and it's just not right. So systemic discrimination is our policies that we really want to change, whereas adverse discrimination are policies that we want to accommodate. So we might have a rotational I think we've got screens in more detail on this, but in adverse discrimination, we might come upon a circumstance where somebody says, yeah, but me, because, and we go, oh, okay, I'm really sorry. I didn't realize that was going to happen to you. Or we knew someday that might happen to somebody, but our policy is to accommodate you so you can have that day off with pay, or you can switch your shift with, somebody else or whatever, and it might work out or we can change your uniform to be satisfactory to meet your religious requirements. So in systemic discrimination, they've got a normal way of doing things in a workplace, which may have a very negative impact on those who are racialized. And examples of systemic discrimination opposed to adverse effect discrimination are things like doing criminal background checks on people for jobs that have no relationship to whether or not a criminal background is even relevant to them doing the job. So if the job is, say, for example, laying sod on municipal ditches, and all they do is get out of the truck, put the sod on the ground and roll it out, and then spray water on it, you have to ask the question, why do I need to know what this person's credit worthiness is? It's not like they're going to steal the sod or have access to information that they might use because they're in financial straits. They're not going to be able to do that. So their criminal background or a credit check for, a landscaper may not be relevant to the job. And so using that as a criteria to hire someone would be inappropriate and possibly capturing people based upon their criminal background or other aspects of their life that got them into financial circumstances, maybe their family history or something. Recruitment practices such as favoring or limiting to word of mouth is considered systemic discrimination. So, very often you go into a business like a restaurant or and everyone who works there is of the same ethnic background, or you go into a particular family-owned business and everyone there is of the same religion. And the reason for that is because they recruit from their personal references and do not recruit from the community. They only recruit from their limited circle. And so that systemically discriminates against all the other people who never even had an opportunity to get this job when they might be the most qualified in order to get it. Steering of applicants to certain jobs or assignments based on race or gender, I think that's pretty straightforward. If you say, hey, that's a woman's job, why don't you go over there? That's a man's job, you go over there. That's not necessarily the case in most cases. Historically segregating occupations or industries. Oh, trucking is a man's industry. No, it's not. And so by identifying an industry or an occupation is much the same as identifying a job or a job type towards gender, or historically those industries or occupations being overgeneralized with respect to a religion or an age would also be considered systemic discrimination. Job ads that include words like young and energetic, or a recent graduate, or men only or women only, would be considered discriminatory. There are, and very often we receive these requests from customers or people, and they say these things to us, and our obligation really is to say to them, if what you want is a person who understands newer technology and is familiar with social media because they're going to be doing a lot of your postings and working on promoting your company through social media, then we don't need to say young. We don't need to say energetic. We don't need to say recent graduate. We need to say familiarity with social media marketing, which might be exactly what they think they're asking for when they say recent graduate, making inappropriate assumptions that old guys like me don't have knowledge of social media marketing. And so we sometimes need to take a look at what is it that we really want to accomplish, because what we really want to accomplish is not prohibited under on discriminatory grounds. But by characterizing it in a way, by generalizing that certain genders or races or ages or physicalities um, might be totally inappropriate in order to reach the objective that we want to reach. Customer preference, systemic discrimination over customer preference. So if the customer keeps telling us over and over again, we need young females to do this job, then that becomes a systemic discrimination. Big data using algorithms to sort through applications. Hey, I don't know of a case yet. I'm not personally familiar with a case yet where somebody has argued that big data using algorithms to sort through applications has resulted in discrimination. But we do need to think about what an applicant tracking system, for example, or posts on social media, or Google clicks might have, what might happen. So let's just say, for example, we're using an applicant tracking system that scans the words in resume and stores those words in the database and categorizes the ones that say the word sales 1,000 times before the ones that say the word sales 900 times before the ones that say the word sales 400 times. And they might prioritize and give you a score based upon the number of times they see a particular word in there. So be careful of the words that we search on and that we use in our algorithms and we use in our search criteria, because we want to be using words and language and do searches in a way that don't unintentionally but systematically or systemically cause the filtering to be discriminatory. The personality or customer service tests, physical ability and capacity tests, cognitive tests. So, I'm a real advocate of behavioral trait profiling. We don't call them tests, we call them interviews or surveys. We try to get a sense about a person's personality to determine if they are assertive or passive, if they are energetic and multitasking, or whether they're methodical and systematic in the way that they do the work, whether or not they're emotional or logical in the way that they approach decision making, whether they're great communicators or whether they're very demure. And so personality tests, if that's what you want to call it, behavioral profiling, can possibly become discriminatory if we are making assumptions about things. So if we are making an assumption that a particular race has this behavioral trait, and we want that trait or we don't want that trait, and we use behavioral surveys or personality tests to determine if they have that trait, then that's discriminatory. It's not discriminatory to say we need people with an extreme degree of confidence to work in this outside sales position. It's not discriminatory to say we need to have somebody who likes to take direction and be supportive of other people in this administrative position. There's nothing wrong with that. That's identifying what traits make people successful, more successful, and more likely to succeed and enjoy their work. when we take those traits and we characterize them towards an age, a race, a type of persons, or a nationality, that's systemic discrimination. So I hope that I've described really. Mandatory religious practices by employers do not qualify as religious organizations. So I think that might mean something like this. If a Catholic school board, I think this is real, a Catholic school board will only hire Catholic teachers who are practicing Catholics who can get a letter from their priest. Now, if you're teaching English, and that's the only thing you teach, you got to ask the question, why would it make any sense whatsoever that a school board would require, a Catholic school board would require a certified teacher to go get a letter from their priest before they could get hired? And so some of these practices still exist for some reasons because they can create a relationship between what they teach and what their responsibilities are and what the person's knowledge or experience is. But most of those things where we've got a mandatory religious practice by an employer are going away because they're finding less and less reasons, or in most organizations, they can tie the two together. Of course, you would need to be Catholic in order to be a Catholic priest, or you would need to be Catholic in order to be a Catholic nun. But you wouldn't necessarily need to be Catholic in order to be the janitor at a Catholic church. English only rules, of course, that makes sense. That, of course, people, many jobs must be able to speak English, but whether or not they speak in other languages is irrelevant or not from a systemic discrimination standpoint. Age limits on benefits, we talked a little bit about that. Mandatory retirement dates have pretty much gone out the window. Waivers that may prevent employers from filing complaints. So if we have a standard practice where you say, hey, you're not allowed to file this, I'm going to remove my right to be able to complain about this kind of stuff. I understand that I may be sexually harassed, and so therefore, but I want the job, so I waive my right to complain. Not allowed. No fault attendance policies. I don't really know what a no fault attendance policy is. I'm sorry. I've been teaching this course for years. That if you've got a attendance policy that says 3 strikes and you're out, 5 absenteeisms and you're fired, and yet the reason for their absenteeism has nothing to do with their behavior or their responsibility, then those policies can sometimes start to lead into family status, financial status, other things like that. So, when you have attendance policies and punctuality policies, you want to make sure that they're well written and they're well thought out. Light duty policies. So, we hear lots of controversies over the years about women firefighters being able to carry certain weights at certain speeds up ladders and things. They need to be absolutely realistic and not overzealous as to become systemic discrimination. Pre-employment medical inquiries, again, become a pretty significant issue. If you're going to have medical screening and testing prior to hiring people, there needs to be some strong correlation to the job in itself. We can't just say everybody has to pass the medical. Maybe those people who operate equipment, heavy, dangerous equipment, have to pass the medical or have to pass the drug screening test. But the person who works in accounting, not so much. So, sorry, I'm going to have a little sip. So now that we've gone through a whole bunch of examples, we compare adverse discrimination, reminding you that adverse discrimination could possibly be a very good policy that unwittingly or unintentionally has an impact on a person or a small group of people, and that policy occasionally may affect them, and that we need to accommodate it. We don't need to change the policy. We just need to accommodate the people that it affects from time to time when and if it accommodates them. So accommodation, we'll talk about accommodation a little bit more later on. And systemic discrimination is not a good policy because it systematically and regularly influences and causes a discriminatory result. And so we need to change that policy. So as I mentioned to you earlier, we hear a lot in the news about systemic discrimination because it's the bad one. We would hear about adverse discrimination because if people refused to accommodate it. So last week in Toronto, there was a complaint about bicycle racks from those bicycle companies where you can rent a bike for the day and drop it off in different places, was put in a place that, if I understood it correctly, was easy to go around for most people, but difficult for people with disabilities, seniors, people using wheelchairs, walkers, very difficult for them. And so it may be a very good policy, their decision that it needs to be X number of feet away from the curb and that it has to be X number of kilometers apart from each other and that there needs to be a certain densification in an area and that the sidewalk needs to be a certain width. But in this one particular place, it didn't work right. And so it could have been a very good policy, but it adversely affected a small group of people. And so they would accommodate that by maybe turning it on an angle or moving it to another corner or changing it to a nearby place. So there's a good example of adverse discrimination and accommodation. Accommodation is a reasonable accommodation in an adjustment made to a system to accommodate or accommodate. We're going to accommodate them by accommodating them. We will to make fair the same systems for individuals based on a proven need. Accommodation can be for religious, academic, or employment related, or other mandated by law. So reasonable accommodation. So recruitment in Aboriginal communities could be reasonable accommodation. So if we're recruiting in a town and there's Aboriginal communities within a reasonable distance of that town, but we only advertise on the sign in the grocery store in town. And their Aboriginal groups have got grocery stores on, nearer where they live, and they don't come into town to do grocery shopping. And then we say, hey, we never hire any Aboriginal people. And people say, well, you didn't apply. Well, I didn't know. Well, how come you didn't know? Because you didn't go into that grocery store. So moving our advertising around to different places, not only relying upon our friends and our referrals, but also moving our advertising around in different places can be a reasonable accommodation. Job advertisements in different languages, in different newspapers, is the same principle. An apprenticeship program directed toward people with disabilities or older workers. So, we often just sort of generally thinking, I think there was a movie made, I think called The Apprentice, and it was, old guy, young female entrepreneur, and the apprentice, is old enough to be her father. And, and it's because we make these generalized beliefs that apprentices are always young, recent graduates, when that all of a sudden becomes a form of discrimination when we make those kind of assumptions. So creating apprenticeship programs that actually reach out to older people or people with disabilities can be an accommodation for an adverse discrimination. Installing software, keyboards, lighting, screens, voice activated devices. These are all very, very nowadays inexpensive reasonable accommodations for people with disabilities or age. Um, and it, and so those are, again, reasonable accommodations that often will be there. Now, there doesn't necessarily have to be adverse discrimination also. There can be no type of discrimination, but yet still a person needs to be accommodated. And so accommodation doesn't necessarily only deal with adverse discrimination, although accommodation is the solution to adverse discrimination. Changing a schedule, remember I talked about the rotating schedule, changing the schedule can easily deal with it. Now, we have this concept called bona fide or bona fide occupational requirement. And the Latin word bona fide or bona fide. And we sometimes refer to it as a qualification, a bona fide occupational qualification. So a BFOR and a BFOQ are exactly the same things. When I grew up, we called it a bona fide occupational requirement. And nowadays, more often, I'm hearing human rights and HR courses using BFOQ, BFOR. A bona fide occupational requirement is more Canadian term, and a BFOQ is more of a US term. These are legitimate qualifications that are allowed to be considered when making a decision on hiring or retaining or promoting an employee that might otherwise be considered or constitute discrimination. So a quality that, when considered in other contexts, would constitute discrimination, but and be a violation of human rights law. But in this particular case, because of the nature of this job or requirement, that we can ask for that. So the example of me saying, you must be a Catholic and have graduated from university and in order to become a Catholic priest. So graduating from the university, we all accept that for all kinds of jobs as being a qualification that's acceptable, but being Catholic is not one, except for the job of being a Catholic priest. So what might otherwise be considered discriminatory in other circumstances is a bona fide occupational requirement in the Catholic priest requirement. So in this particular case, Mr. Christie was employed at the dairy pool, it's called the dairy pool, and became a prospective member of the Worldwide Church of God in 1983. The church recognizes Saturday as a Sabbath and 10 other holy days throughout the year. Members of the church are expected not to work on the Sabbath or on these 10 holy days. Mr. Christie asked his employer for permission to take unpaid leave. So he didn't ask to switch his shifts. He just asked for an unpaid leave on Tuesday, March the 29th, and on Monday, April the 4th of 1983, because both days were holy days in his church. He was granted leave for the Tuesday, so he was partially accommodated, but he was denied the unpaid leave on the Monday because, as the dairy pool says, Mondays were especially busy. And milk arrived over the weekend, and it had to be processed promptly on Mondays to prevent milk spoilage. When Mr. Christie took his day off on the first day off with permission, but was not going to violate his religious obligations. And so he just didn't show up for work on Monday, the April 4th. So he was absent without permission. And as a result, his employer terminated him. Clearly, in 1983, this was not the same recruitment shortage of candidates market that we are living in today. Anybody who fired a person for 1 day of absence today would be shooting themselves in the foot, cutting off their nose to spite their face, and just be terrible employers. The Board of Inquiry ruled that Christie was discriminated against because his religious faith had not been accommodated or reasonably accommodated. However, this decision was overturned by the Alberta Court of Queen Bench and the Alberta Court of Appeal. So this is interesting. We've got a situation here where the first court said, hey, that's bad. And yet somehow the dairy pool appealed it to a higher court and they got their ways. The Board of Inquiry originally found that the employer made no significant effort to accommodate their request. And they were unable to establish a bona fide occupational requirement. Bona fide occupational requirement principle question raised in this appeal was whether a particular attendance rule imposed by the employer or employee is a bona fide occupational requirement. If it is a bona fide occupational requirement, could the charge of religious discrimination be proven that the employer accommodated the employee up to the point of undue hardship? So, look, I'm reading this stuff. Basically, here's the deal. The issue becomes, number one, is it true? Is it really important that they have full staff on Mondays because of all the milk that comes in over the weekends and the cost of spoilage if they don't get through it? Is it really true that this amount of milk spoilage cannot be averted by 2 people staying for a couple of hours afterwards, or by 4 people staying for 2 hours afterwards, or by them getting a temp in or something? Is it really expensive? And is it really true? And if it is really expensive and really true, then it could really be a bona fide occupational requirement that people come to work on Mondays and have no exceptions, that they come to work on Mondays. Because when you take a Monday off, while your wage might be $200, it costs us $2,000 or $20,000. And so first off, we have to determine, is it truly a bona fide occupational requirement? And then the second question has to become, is it reasonable? Is there a reasonable way that an organization can overcome that they could get a temp in? And obviously, in this particular case, in the first case, the first judge said, hey, the guy took a day off. He was away for a day because of his religion. You didn't accommodate him. But when they went back to trial and appealed it, they were able to establish that there was truly a bona fide occupational qualification and that there was truly such a significant hardship that could not be reasonably accommodated. Now, I don't know, like I wasn't there for the case. I think that if nowadays, if we were to look at it and say with technology and the way that we milk cows and how we pasteurize and store milk and the equipment that we use and the storage facilities that we have and the amount of processing that you just keep the machine running for another hour or getting temps in, I think nowadays that probably wouldn't have flown, but it did at that point in time. And, I sometimes use the example of the heritage building. Let's pretend that there's a 300-year-old prison that has got a section where in order to get into the cell, there's a 3-foot thick stone wall, and they create a little slot that goes zigzag into the area. And so they've got bars and they've got doors, and over there they've got bars and doors and walls and spike things and whatever they had 3 years ago to make a prison. But one way that they could stop a massive prison break was have this one narrow entrance where you had to turn sideways and slide in and turn and go across and turn and go this way. And only skinny people could make it through there. And so unfortunately, heavy set inmates, once they got in there, if they put on too much weight, they were never going to get out. That only skinny guards could work in that place. Well, that was 300 years ago. Weird decision, right? And by the way, I'm making this example up. I'm making this example up because I went to a prison one time that had a really skinny area to go through. I don't know why I was there, but I could barely get through it. So I'm making this example up. So today, this is a historical site, and we're hiring people who give tours. And when you give the tour, you say to people, hey, you can't go on that ride safely unless you're above this height. And you can't see that part of the prison unless you're this skinny, because you can't get through the wall. And we're not going to tear down a heritage building and blow up the wall so that just some people, 10% of the people, can get in there. You can watch the video. And but the tour guide has to go in and out of there 25 times in the day. I think it's reasonable to say that the tour guide must have a body shape that fits through there. So it's not discrimination to say that in order to, I can't reasonably accommodate a person. A heavier person, I have to blow up a heritage building and knock down 3-foot wide heritage walls. And part of what we're showing people is for this heritage building is the wall. So somebody might argue, hey, cut the wall out, set it over there, use it as an example, explain to people. Okay, is that reasonable or not? The whole point is it we can accommodate almost anything. Is it a reasonable accommodation is the question. In 1985, this precedent-setting case with the National Railway that went to the Supreme Court of Canada, decided that the requirement of wearing a hard hat is not a bona fide occupational requirement and amounted to discrimination on the basis of religion, which entitled a Sikh worker to continue in his employment without having to wear his hard hat. Now, we had the same cases around the same time with RCMP officers wearing their religious head coverings and not wearing an RCMP hat. In this particular case, this was the Canadian National Railway, and it had to do with wearing a hard hat. So here are some of the facts. There was no shortage of maintenance electricians. Mr. Binder was not a unique or specialized employee. He was a maintenance electrician. The employer's safety policy would not be jeopardized by Mr. Binder, by giving Mr. Binder an exemption. Mr. Binder was willing to relocate to a job post at a location where a safety helmet was not necessary, though he was not willing to assume duties other than those of a maintenance electrician. Mr. Binder, so he said, as long as I get to be a maintenance electrician, I'll work over there, I'll work over there. I just, if you need me to wear a hard hat over here, but I'll gladly go to the other location. So he was willing to perform his duties. Mr. Binder was able to perform effectively and efficiently without his helmet on. So it wasn't like having to wear some piece of equipment that made you efficient. Mr. Binder's fellow employees, nor the general public, were put at risk because he didn't wear a safety helmet in those locations. A risk of injury to Mr. Binder if he did not wear a safety helmet was very small in these new locations. And so, which of the following is not as, so to finish off that case. So we were able to show that they could reasonably accommodate him. He could do the job in other locations. He wasn't going to hurt anybody. He wasn't going to hurt himself. He wasn't likely to hurt himself. He could continue to do his job. And the railway, CN, was originally adamant for safety reasons that everybody wore a hard hat. And you know, the old adage, you give one person an inch and everybody wants to be a ruler. Well, in this particular case, the old adage didn't work because the law says that he needed to be reasonably accommodated. Which of the following is not a discriminatory practice? This is the part that works very well for a live audience. Denying someone goods and services or facilities or accommodation based upon a prohibited ground. Of course, that is discriminatory. Denying an employment opportunity based upon a bona fide occupational requirement. What? It's a bona fide occupational requirement. So if we deny a person because they don't meet the bona fide occupational requirement, that is not discrimination. Paying men and women differently when they're doing work of the same value. Ooh, that's an interesting one. Let's come back to that one. Retaliating against a person who has filed a complaint with the commissioner or against someone who has filed a complaint against him. So yesterday we talked about reprisals. So reprisal, retaliating against a person who had a complaint or thought they had a legitimate complaint based upon a human rights violation. So reprising or retaliating against that person is discrimination. Harassing someone is discrimination. So let's go back to number C. Which of the following is not discrimination? Paying men and women differently when they're doing work of the same value. This is an interesting wording because work of the same value is not necessarily the same work. So if two people are doing the same work, and if two people have all the same qualifications and it's at the same location and they have the same seniority and they've got the same merit, they've accomplished their 3 stars, 5 stars, teachers go and take courses that upgrade their certifications as they go through their career and they get paid more money. So someone might say one person teaching grade 2 and another person teaching grade 2 are both of the same value, but they get paid different amounts of money for different reasons. Those different reasons, so long as they're not gender, are okay. So if we're paying men and women differently for work of the same value, we really have to ask ourselves, are they doing the same job and have the same qualifications and all the same criteria that I went through? Using the word same value is misleading. That's a concept of pay equity, which is not pay equity is not where we look at the value of a job and try to make sure that all the people who work in a job of this value get paid the same as people in a job of that value is very questionable. Western School District, case number 3. In a unanimous decision, the Supreme Court of Canada restores the decision of the BC Council of Human Rights, which found that Mr. Smith was, so this went to court, then it went to higher court, and they all found the same thing, that Mr. Smith was discriminated against by both his employer and his union because of his religious belief. So Mr. Smith was a school custodian. He's Seventh-day Adventist. His religious belief prevented him from working from sundown Friday night to sundown Saturday. The work schedule, which required him to work on Friday night shifts from 3 p.m. to 11 p.m. was set in a collective agreement between the Western School Board and QP Local 523. Accommodating Mr. Smith's religious beliefs would have required allowing him to work hours different from those specified in the collective agreement. and the respondent school board and union could not agree on a means to accommodate Mr. Smith, and as a result, he was dismissed from his job. Now, by the way, schools very often have Boy Scouts, Girl Guides, volleyball league, badminton league, floor hockey thing, theater club that rent school gyms and school theaters. And very often, schools and school boards have policies that nobody can rent it unless there's going to be a custodian on site. So there has to always be a custodian on site when somebody's occupying the school. It wasn't like that when I was a kid. If they're going to rent out the schools on Friday nights, then they need to have enough custodians around that they can come to work on Friday nights, and they have to modify their schedule so that maybe they don't work on Monday mornings, because the school is clean on Monday mornings, and there's already maybe 2 custodians instead of 1 or something. And so this is pretty normal. Like there's a bunch of intertwined policies here. We rent it out. There must be a custodian on site. This is for safety. This is part of the union agreement. There's a bunch of moving parts here. The council concluded that Mr. Smith should have been accommodated, and both the employer and the union were liable for failing to do so. So basically what they said was, hey, look, we understand that you've got a policy that you have to have a custodian in the school on Friday nights, but you haven't proven to the court that you couldn't have figured out a way around this, that you couldn't have, rented it out on Thursday nights instead of Friday nights, that you couldn't have found a custodian from a different place, that you couldn't have modified your shifts to accommodate the custodian. They didn't have to be there on Friday night. They were there at other times. So there's all kinds of, basically they failed to prove that it was a bona fide occupational requirement, and they failed to prove that it was unreasonable to accommodate the custodian. Systemic discrimination, boy, Hockey Canada, they're just always in trouble. Hockey Canada agreed to make changes to protect young players in Ontario from discrimination and harassment based upon players' transgender status. These changes resulted as a human rights application filed after facing difficulty at one of its local arenas. So the resolution was made that by Hockey Canada. They agreed that all facilities would provide training to all of its Ontario-based trainers and coaches on gender identity and gender expression, including training on discrimination and harassment. And Hockey Canada also agreed that it would amend its Ontario co-ed dressing policy, which will be publicly posted on the website. So I don't know what the dressing policy was. I don't know what it is, but we know that they went to court. Some transgender hockey player family or team that had a transgender player went to court, sued Hockey Canada for systemic discrimination, and they came back and said, okay, so there wasn't a penalty, there wasn't a fine, there wasn't go to jail, do not pass go card. There was simply an agreement or a resolution that Hockey Canada needed to provide more training on transgender to their coaches and to their trainers on transgender identity and transgender and gender expression. And they needed to include this in their discrimination and harassment policies. We know that whatever their policy was about a person's right to use or have access to dressing room, it's got changed to accommodate their needs. I'm sorry that I don't know what the policy was or what it is, but the important thing to note is this. We've got a topical issue of gender identity. It wasn't gender identity. Gender was covered, is covered under prohibited grounds in the charter and in the legislation. Gender identity was not. And so when self-identification became an issue that people felt comfortable to take to court, it went to court. And it followed that process where common law was established, that people began to look at gender identification as similar to the same in the same categories as gender, family status, so on, and that they would now start to deal with this in a particular way. And in this particular way, the accommodation was appropriate training. So, oh, here it is. A player has a right to use a dressing room that corresponds with the player's self-identified gender. A player shall be addressed by the player's preferred name and referred by pronouns corresponding to the player's self-identity. A player is entitled to privacy and confidentiality with respect to the player's trans status, and information about the amended policy accessible to staff, volunteers, and parents. And information about the amendments will be available to everybody. I don't know if this is good. I think this is controversial. I think people are still debating it. In this particular accommodation, they said you got the right to use the dressing room of your choice. You got the right to be referred to the way you want to be referred to. And nobody else has the right to know what your status was prior to this identification. As far as we're concerned, if you identify yourself as a woman, you're a woman. If you identify yourself as a man, you're a man. And this became the systemic discrimination change in policy, not an accommodation, a change in policy, because systemic discrimination is a bad policy where the policy needs to be changed. Okay, so let's test our knowledge on some of these things. A policy provides benefits to some married couples, but not others. This may be a case of discrimination based upon family status. A person is identified, a person is denied a job because of a previous conviction for which a pardon has been granted. So this person has had a previous conviction, but they have received a pardon, and or their record was suspended. So this is discrimination based upon pardon conviction. Pretty straightforward. Oops, I pushed the button. So obviously number 3 is disability. An employee has a reaction to dust and chemicals at work and needs to take 2 days off work. The employee needs the company's address for the WSIB forms to be filled out properly by her doctor, but her supervisor refuses to give her the information necessary to fill out the form. She's told that there's no place for her to work at a company because they don't want to be filing workplace safety and insurance board claims every other day. So I'm not going to give you the information, she said. So in this particular case, her allergy was considered a disability, and the ridiculous response by the supervisor was considered discrimination. Number 4, a female employee with an excellent performance record announces that she is pregnant. Immediately, her employer begins to identify performance issues that lead to her dismissal. This may be a case of discrimination based upon which grounds? This is on family status. Now, they use the word may because the way that this is worded implies that that's the only information. Female employee, great employee, got pregnant, got treated badly. So the implication is that there's a relationship between getting pregnant and being treated badly. There may be other circumstances. We don't know what those other circumstances are, but if these are the only circumstances, family status. A female employee is an excellent. Number 5, an employer assigns her employees to weekend shifts without recognizing that some employees observe the Sabbath and cannot work on those days. This may be a discrimination. We've talked this one to death already today. Discrimination based upon religion. Number 6, an employer's physical fitness requirements are based on the capabilities of an average 25-year-old. I don't know what the physical fitness of it. I guess, I think all 25-year-olds are differently physically fit. But The employer's physical fitness requirements are based upon the capabilities of an average 25-year-old instead of being based on the actual requirements of the job. This may be a case of discrimination based upon age. Okay, so we got that. True or false? Is harassment a form of discrimination? The answer to that is yes. Harassment is a form of discrimination. It involves any unwanted physical or verbal behavior that offends or humiliates you. Sorry, I'm looking at the clock here. I forgot that we're taking breaks today. We're taking a break in 10 minutes. Harassment is a form of discrimination. It involves any unwanted physical or verbal behavior that offends or humiliates a person. Generally, harassment is a behavior that persists over time, a series of incidents that it's an accumulation is considered to be discrimination. Sometimes it can be one severe event or incident, which has a lasting impact on the individual. Serious one-time incidents can be sometimes be considered as harassment also. So if there's this persistent, recurring, repeated, systemic form of harassment, it is discrimination. If it is a one-time serious event that is obviously related to a prohibited ground. So I guess what they're saying here is you can be mean to a person at work, and if it's not based upon any of the prohibited grounds, it may not be considered harassment. But if it persists on a regular, recurring basis, regardless of the prohibited ground, one man, white man, persistently harassing another white man, middle-aged white man, that would eventually rise to the level of discrimination. Most harassment falls under an area of prohibited grounds. Harassment occurs when someone makes unwelcome remarks or jokes about your race, religion, sex, age, disability, or any other grounds of discrimination. It threatens to intimidate you or threatens you. It makes unwelcome physical contact with you, such as touching, patting, pinching, or punching, which can also be considered an assault. So this harassment almost always includes prohibited grounds. It has to make you feel threatened or intimidated. It has to be unwelcome. Where can harassment occur? Hey, harassment can occur anywhere. Harassment doesn't have to happen at the workplace. So if a bunch of people who all work together go out for drinks every Thursday after work, or go sail on a sailboat, or go to dance lessons, if the harassment occurs there and makes a person feel uncomfortable, then it is harassment. And it doesn't have to be at the workplace. So this whole thing is, no, that didn't happen here at work. It's not related. So this is why, companies just, hey, that's unwork related. If it's a one-time event and it's not so significant, then a company would get away with saying, hey, that's not work related. If it's persistent and it occurs at and or away from work, and it's between two employees, then it would be considered harassment. Is there a time limit to file a harassment complaint? The answer to that is yeah, 12 months from the last date in which the alleged harassment took place. And I guess the controversial part about this is, and we see it all the time, especially in police shows and legal shows, and we hear about it in the news, that victims of violence, harassment, sexual assault, discrimination are often so traumatized by it and so intimidated by it that they don't just complain. They don't just, hey, it happened, I'm going to find out what I need to do and file a complaint. that very often we hear these allegations of harassment or discrimination or violence or sexual harassment um, many years later. But as time goes on, the remedies become far more difficult to become reasonable. And so they've basically said, look, complain or get off the pot. Let's give people time, and a reasonable amount of time for most complaints is 12 months from the last incident. So if you went for 2 years having complaints, and you did or did not complain about it, you tried to resolve the issue yourself, so the person stopped, and then 13 months later, 15 months later, 2 years later, they harassed you again, the clock starts again. You can file the complaint at that point in time. Identify and select answers below that does identify and select the answers below that do not constitute harassment. What is not harassment? Discrediting the person by spreading malicious gossip or rumors, ridiculing, we have to go on, ridiculing him, humiliating him or her, calling into question his or her convictions. I think that constitutes harassment. A single or isolated incident, such as an inappropriate remark or having an abrupt manner, typically that is not harassment. If it's a single or isolated event and somebody pats you on the butt or yells at you or makes an inflammatory comment, you're expected to deal with it. And if it stops, it's done. It's offensive, but it's not considered harassment under human rights policy. Unwanted sexual advances may or may not be accompanied by threats or explicit or implicit promises. Unwanted sexual advances, which may or not be accompanied by, so this is what we call quid pro quo. If you do this for me, I will do that for you. If you don't do this for me, I will do this to you. Harassment. Quid pro quo. This for that. So we'll come back to quid pro quo in a few minutes. Making rude, degrading, or offensive remarks. This is harassment if it is persistent and repetitive. Friendly gestures among coworkers, such as a pat on the back. This is not considered harassment. This friendly gestures amongst coworkers, if it's a one-time incident. If it is a repeated incident, if it's a pattern of behavior, then it is considered harassment. Isolating the person by no longer talking to him or her, denying or ignoring his or her presence, distancing him or her from others. So when we've got a person who has made a complaint and we go into this passive aggressive punitive behavior, that would be considered harassment. So the two cases, it says, which are not considered harassment, a single isolated incident is not harassment, and a friendly gesture is not harassment. The single incident has to rise to such an extreme or appropriate level that it has lasting effect. And the friendly gesture by coworkers, such as the pat on the back, if it's not a recurring systemic part of a practice in the workplace, then it would not be considered harassment. It is now 2:28 and time for us to take a 10-minute break. We're going to come back. I thought it would take 30 seconds. Okay, we're back. So the next little section we're going to talk about is quid pro quo, which I really talked to you about already. So we'll go quickly over this screen. Quid pro quo is not in itself a harassment or discrimination. It's just simply the Latin expression for something or this for that. And, it usually very often can be innocuous and used in a non-offensive way. The term can say, I'll do this for you if you do this for me, and it's bartering, of sorts. But it's very often used also when we're talking about sexual harassment and intimidation. So in a workplace where a manager or authority figure hints that he'll give a person a promotion or a raise or an opportunity or something in exchange for sex or a relationship, that is often referred to as quid pro quo. And of course, that's absolutely and totally inappropriate and a form of discrimination. So it just in summary, with the Human Rights Act, the act in itself, it is the principle that all individuals in Canada should be given an equal opportunity to make for themselves the lives that they're able and wish to have, and have their needs accommodated by their employer. The act is meant to promote this equality by prohibiting discriminatory practices, and it's based on specific attributes such as race, ethnicity, sex, and so on, which may hinder or prevent a person from doing so. So it's really all about fairness and opportunity and accommodation. And I think that we've, I've talked to you about the differences between provincial and federal. And so let's move on to the principles of diversity, equity, and employment equity. So the Employment Equity Act is federal legislation that almost certainly doesn't apply to you. It's important that from a recruitment and hiring perspective that you understand it. It's also important that if you're a supplier to the federal government that you understand it. And it's also important to understand it because a lot of times people use the term employment equity, and if they're using it correctly or not using it correctly, it's important to know what also doesn't impact you, what is not your responsibility in operating your business. And so very often people make statements about employment equity provincially that are not accurate. And so we need to make sure we understand this. So the Employment Equity Act is federal legislation which requires all employers, federally regulated employers, to engage in a proactive employment practices to increase the representation in 4 designated groups. Now, remember, I can't emphasize more. This is not provincial legislation. This does not directly affect staffing companies unless you are a provider of services to the federal government, and unless the services that you provide are significant, I think $500,000 a year or more. There are some other circumstances, like for example, I once dealt with a company that was into medical equipment and food processing equipment that was covered under federal legislation because of something, for whatever reason, because of the cross-border nature of food and this medical equipment. So this federally regulated company, we did a lot of recruiting for them. And so every candidate that came through, we collected the information on our customer's behalf because our customer was federally regulated and had to comply with the act. So it's not going to affect you directly, but it might affect you indirectly if you are a federal government supplier under the contractor's provision of employment equity, or if you're like me, had a contract with a federally regulated company and they wanted to outsource some of the administration to you. So this basically takes a look at women, people with disabilities, Aboriginal people, and visible minorities. And it asks us to take a look at the communities that we work in and to get statistics on what percentage of the working population fits into each one of these groups. And then to collect data inside our own companies to try to determine whether or not our workforce accurately reflects the diversity of these 4 designated groups in the community. And so if 10% of your community is Aboriginal people, which of most communities that would be extremely high, but let's use that number, 10%, but your workforce only has 1%, then the Employment Equity Act would say, hey, what is it that you can do inside your company to change some of your to proactively change some of your employment practices and hiring practice so that you might end up eventually hiring a higher percentage of Aboriginal people to be reflected in your workplace. So employment equity is designed to achieve equality in a workplace so that no person shall be denied employment opportunities or benefits for reasons unrelated to their ability, and to correct the conditions of disadvantages of employment that are experienced by women, Aboriginal people, persons with disabilities. So we want to have this equality in a workplace, and we also want to correct the inequality, that occurred in the past, which has resulted in the numbers that we have today. These are not quotas. These are not obligations. This is not anything that you might hear about, and people complain more particularly in the United States about, oh, they hired that person because they were, part of this particular group. That's not the case. What this does is this says, what kind of practices do we have that have resulted in this disequilibrium so that it does not represent the balance and the percentages in the community? What practices have we had in the past that have, for some reason, resulted in the fact that we've got different representation in our company than what exists in the world around us? And if we change the practices, then over the course of the long term, we'll change the outcome. And the changes in the practices are supposed to be proactive changes in order to eventually get you to a point where your company looks the same. There's no obligation on any person, on any people, on any numbers. There are no goals. There are no targets, nothing like that. It simply says, do you know what your community is? Do you know what your workforce is? Is there a difference? What are you doing as general practices to change those? So the labor program, the provincially regulated suppliers to federals, is a special labor program that's responsible for ensuring compliance with employment equity requirements under the federal contractors program for provincially regulated companies like us, who are providing services to the federal government. Say you're providing temporary staffing services or recruitment services for the federal government, and you've got 100 or more employees, and you've been awarded a contract or a cumulative contracts of $1 million or more. And so if you do $1 million worth of business with the government, if you've got 100 employees or more, and you're doing business with the federal government, then you're supposed to collect the data also. And if your data is out of whack, then you're supposed to introduce some of the policy trainings. So there's some free training modules that are available at that link. Hopefully you've got a printout. It's a long bunch of words that you have to type, but you can find those training modules. The screen looks like this. It's available in English and French, and it's there for private sector, provincially regulated companies like us, who provide over $1 million worth of business a year, or 100 employees. Now, by the way, one time, one of my companies, we really didn't want to do this because we didn't really feel it was advantageous to anybody in any way based upon the services we were providing and so on and so forth. And so we made the case. This was, I obviously had far more than 100 employees, including all of our temps across Canada. But this is for an education thing. And I had an education office in Ottawa that only worked on these education contracts with Ottawa. And we were able to convince the government that we really should only count the number of employees working on our education project, which was like 12. And so they said, oh yeah, you don't have to comply with this. So there's lots of flexibility with it. The first step in an employment equity program is to conduct this workforce analysis. So you survey all of your employees and you have them confidentially fill out these self-identifying forms saying if they fit into one of the designated groups and which one. And that information is stored elsewhere. It is not in their HR file. It's not in the employee's file. It gets stored in your employment equity file that is only used for statistical purposes and is not used by anybody in the company to determine if you're Aboriginal or disabled or female or male or visible minority. So then we conduct an employment systems review. So we take a look at all the systems and processes for hiring and employment in the company and ask ourselves what some of things could be leading to the numbers that we have and the balance that we have. Then you create a plan, which will have dates and things that you change. We're going to change where we advertise. We're going to change the food we serve in the cafeteria to apply to certain groups. We're going to change the schedule of work and how we rotate work. We're going to change our referral program, and you change a bunch of these things, and hopefully over time you get a different result. You have to establish and sustain the program. So first you do the research of the workforce, then you do the research of your company, then you develop a plan, and then you implement the plan, and you submit a LEAP report, an annual report to the government every year. And so long as you're doing those first 4 things, the workforce analysis, the market analysis, you have a plan and you implement the plan, then you're good to go. Multiple choice. Employment equity involves all of the following except identification of systemic barriers to employment opportunities that adversely affect designated groups members. Yes, it applies to that. To government imposed quotas. No, there are no quotas. Plans to overcome employment barriers. Yes, we want to knock down employment barriers. Reasonable accommodation. Sure, okay. Being proactive in planning an annual employment equity plan. Yes, we do. So the only thing in there that the employment equity involves everything except for quotas. There are no quotas in employment equity. What are 2 major demographic pressures affecting the Canadian labor force today? The large number of baby boomers approaching retirement age, the shortage of young people available to replace them. Hey, you know what? This screen was made a bunch of years ago, and, you know, we update legislation and things. This, 10 years ago, I don't know how long this screen's been in this presentation. This issue of baby boomers and the shortage of young people, I'm old. I've been in this business since 1983. We've been I know some of you weren't born in 1983. We've been talking about the issue of baby boomers approaching retirement age. And so you've got this one, question of baby boomers are approaching retirement age and they're all going to leave the workforce. And this massive bulge in the workforce is, going to create a void, and that the young people won't be able to replace them. And yet there's this other issue going on where baby boomers don't want to leave the workforce. They want to continue to have their cake and eat it too. Baby boomers want to work from home. Baby boomers want to continue their income. Baby boomers want to do, so they're not leaving. And so young people aren't seeing opportunities. And housing prices are going up because baby boomers kept on getting richer and kept on upgrading their houses and affecting the marketplace. And they kept working and kept having income in order to be able to afford these ridiculously stupid housings. So there's a whole bunch of issues that go both ways. We talked yesterday about the issues that go both ways and raising minimum wage. We also have this issue of baby boomers. Now, without a doubt, eventually baby boomers are going to have to quit, and eventually baby boomers are going to die. And there's going to ask, the question is, what are the younger people or people coming into the workforce? What do they want to do? What are they being trained to do? What kind of education do they have? What kind of opportunities are we giving them while they're young to prepare them for when they're older? What are the differences in cultural beliefs and desires of younger workforces in the various gens as they come into the workforce? And, are we able to work together? Are we able to respect each other? Are we able to identify how we create a work environment that will attract different gens in the workplace. These are all questions that find their way into equity and discrimination, because the people with power and authority, typically who are the ones that are more senior in the organizations and different, older and been around for longer, are not necessarily modifying and changing their beliefs, their patterns, and their systems and process and business models to accommodate the changes in demographics and the changes in beliefs within various demographics. Now, in Ontario, we've got this thing called the Accessibility for Ontarians with Disability Act. This was introduced, I can't even remember what year, 2010. It's a long rolled out process. The Act speaks to the development of implementing and enforcing accessibility standards by all employers in order to achieve accessibility for Ontarians with disability. This is with respect to goods, services, facilities, accommodations, hotels, employment, buildings, transportation, buses, structures, premises. You have seen, particularly for those working in Ontario, you have seen a radical change in transportation, in buses in around municipalities in Ontario. And this isn't only because the technology of buses has changed. This is because Ontario made it the law that people who were in wheelchairs and walkers and were old and couldn't lift their foot up to step up on the bus and were uncomfortable and they're seating on a slippery bench with a pole, that they needed to accommodate people. And so now buses tilt and lean and steps come out and raise people up, and they've got wheelchair spots where wheelchairs can be locked down. And you would think that a lot of this has to do with the advancements in technology, but a lot of this is because the government of Ontario 15 years ago introduced the Accessibility for Ontarians with Disabilities Act, and many of these changes over time have taken place. So there's 5 different sort of stages of the OADA. And every company, it was 2005. So boy, we're talking, almost 20 years now, 18, 17 years. 2005. The first part was customer service. So the first part had to do with training all of your employees, all of our employees, to understand how to speak to and accommodate people with disabilities. The second part of it was information and communication, where we post our information, how we communicate our information, how we post our training information, how we post and share our accessibility information, whether it be signage, whether it be stuff you go onto the website. If you want to go into the Eaton Center and go to a retail or a business, you can go on there and look under accessibility, and you can find out where all the wheelchair ramps are and where all the elevators are to get you to the location that you want to go to. You don't have to wander around the Eaton Center banging into stairs and thinking you're in a maze. So that's part of the information requirements and communication requirements. It then needs to translate into employment, and that had to deal with accessibility. It had to be able to get in to do your interviews. It had to deal with accommodations of equipment. And so this is why we've seen a proliferation of voice activated and other type of accommodations, so that people with disabilities, with their hands, with their mobility, with their vision, are being accommodated much better by using technology. I mentioned transportation. This is the biggest, this as far as I'm concerned, the biggest, most obvious change. We've been seeing elevators and ramps pop up everywhere, but transportation is the most obvious change. And the interesting thing is this, so here's a story so you can understand the implications of this. And this is a little bit of a backwards story, but I have a 28-year-old daughter who for her entire life has been in a wheelchair, and she qualifies for trans help, or wheel trans. In your community, it might be called something else. In Mississauga, I think it's called trans help. In Toronto, it's called wheel trans, but they're the same. And so she qualifies to have buses, for a fee. You pay similar, it's a little bit more than the average bus ride, but you can pay to have a wheelchair accessible van come to the house, pick her up, drive her to school or work or store, doctor's appointment, and drop her off and bring her back. Now, she's not capable of doing that on her own. So she really isn't, she's qualified for it, but her permit says that she has to have an aide with her. Well, interestingly enough, when the accommodation for number 4 came along a couple of years ago, 2 years ago, and all the municipalities were required by law to meet the transportation requirements, they said, hey, if this person can get out with an aide and get on a Wheel-Trans bus, they can now get on our regular buses. So they took away her Wheel-Trans or TransHelp accessibility, because they said, you know, all of our buses now come within a kilometer of your home, and you know, she's got to be with an aide, so the two of them can go down to the bus stop and get on the bus and take the regular buses instead of having us come to the house. So, you know, in fact, that didn't work out so good because I don't have any sidewalks in my neighborhood in winter, and she's in a manual wheelchair. So that didn't actually work out too well. They made a little bit of an error in their judgment and backtracked on it. But the important thing to note from this is that they made such significant progress that a tremendous number of people who otherwise could have only gone out of their homes if they had a Wheel-Trans or TransHelp come to the door, or a wheelchair vehicle come to the door, that now public transportation can move them around. So this is cool. Built environment. So this has to do with ramps, elevators, lifts, and all kinds of things to accommodate people in their built environment. So 1 in 7 Ontarians has a disability. They're very often not visible at all. 95% of the disabilities are hidden. So it could be disability defined by vision, by hearing, by mobility, by cognitive disabilities, communication, you know, all kinds of things, from their flexibility. And many of these disabilities, 95% of them, according to this statistic, are not readily visible for people to see. So if we go back to the employment equity discussion about people being self-identified and filling out a form, and companies keeping statistics, it's not just good enough for a company to go, oh yeah, we got 7 people with disabilities. It's very possible that up to 95% of the people that work for them could potentially fall into that category. Now, it's not 95% of workers, it's 95% of people. So, you know, a significant portion of those people are 65 and older and possibly not working, and they've developed disabilities in their old age. But the reality is a significant percentage of people have hidden disabilities. It's estimated that 1 in 5 Ontarians will be 65 or older by 2025. I think we're at that number now, 1 in 5 Ontarians 65 and older, but it's estimated that 20% of our entire population will be over 65, and half of that group will have some form of disability. So we're going to see, you know, half of our seniors over 65 are going to have some form of disability. More than 500,000 Canadian adults have some form of vision loss. Hello, can't see you. More than 500,000 Canadians have some form of vision loss that is not corrected by glasses, and more than 500,000 live with some form of hearing loss that's not corrected by a hearing aid. So it's, you know, one of the most common things that we hear in our home care business. And it sounds like a discriminatory comment, but what happens is we've got a tremendous number of caregivers and nurses and medical professionals and aides who work for us who have an origin other than Canada and speak English as a second language. And so they have heavy accents. And in our home care business, the vast majority of our clients are seniors, and the vast majority of them have hearing disabilities, and also a significant number of them have cognitive disabilities with the formation of dementia and Alzheimer's. So here you've got this aging group in our population who don't hear so well, and when they do hear well, have difficulty understanding. And so speaking clearly and directly, using body language and using cultural intonations that we're all familiar with, have important meaning and effectiveness in some of our aging population to understand, to hear and comprehend what people are saying. And yet we've got also an increasing population who speak English as a second language with heavy accents, and also culturally nonverbal communication cues that are very often different. You know, if you live in a particular community, grow up in a part of the world where certain hand motions mean things and other things mean I'm mad, or, you know, I don't know. But culturally, we all grow up with, you know, different cues. We don't think about it very much until we become confused and don't understand. So we've got this growing and increasing challenge. And we got to ask ourselves, how does this affect us at work? How does this affect us in our hiring? How does this affect us in the way that we serve our customers? And these are all very, very important issues. And OADA, the Ontario Accessibility for Disabilities, Ontario, is intended to help us address this. Mental illness also affects Canadians either directly or indirectly through a family member, a friend, in an incredibly high percentage, and particularly when we start to consider two aspects of mental illness that we don't always think of. One is stress and anxiety, which is happening from people coming into the workforce, dealing with COVID, dealing with the threats at work, financial stresses. So there's stress and anxiety, which can be considered to be a mental illness. And on the north end, on the high end of we've got an increasing number of people with Alzheimer's and dementia, an increasing number of customers and so on. And then, of course, we've got this whole plethora of mental health issues that just, you know, cover the whole spectrum in between those. And we as employers, if we've got a shortage of people in our workforce, if we've got customers that have got special needs, if we've got employees who have got those special needs, we need to increasingly become more aware and conscious about the decisions that we make and how we're going to try to take advantage of this workforce, take advantage of the opportunities, and to accommodate people in such a way that our businesses can thrive and our employees can thrive and our customers can get the service that they need. But there's ways to take advantage of all of these things by doing them well and doing them right. So disabilities can include physical disabilities, infirmity, malformations and disconfiguration, conditions of mental impairment, developmental disabilities, learning disabilities, mental disorders, injuries, everything we talked earlier about. Allergies can be considered a disability. A lot of injury or disability for which a benefit, you know, we also got to think about injuries that are covered by the Workplace Health and Safety Act, so people who are harmed at work, and some of those can be repetitive strain injuries and other injuries. Disabilities may be visible or invisible. They may be continuous. They may be intermittent. They may be temporary, and the individual may overcome their disability. They come in obvious, severe forms, and they come in very hidden forms. Information about a person's disability is personal and must be treated with privacy and confidentiality. But I can't help but emphasize for you that the companies, the organizations, the people, the recruiters who identify the fact that we've got an increasing number of candidates to choose from who fit into this category. We've got an increasing number of customers that have got issues with themselves, with their own employees, with that we need to service. And also think about, you know, not just like our customers, like corporate customers, but think about a bank who's trying to serve their customers at the counter or at the ATM. Think about the insurance company that's trying to deal with the senior who doesn't hear well over the phone when they've had a flood in their basement. organizations that understand and respect accessibility, accommodation, the differences in people because of disabilities, because of their culture, because of their abilities, are the ones that are thriving today. And the ones that are stuck in the days of discrimination and that everybody must look like this or play like this or act like this or be served in this particular way are the ones that are falling behind the wayside. And so it's important for you, not only from an ethical standpoint, not only from a legal standpoint, but from a strategic business standpoint, that you understand that this is important for you. So AODA means that you have to have a policy statement and organizations. And so here's a sample statement. Our organization is committed to providing exceptional and accessible services to our customers. Our services will be provided in a manner that respects the dignity and independence of all customers. The provision of services to persons with disabilities will be integrated whenever possible. Persons with disabilities will be given an opportunity equal to that given to others to obtain or use or benefit from the services provided by our organization and on behalf of our organization. So this is a sample policy statement. You can take it verbatim. If you don't have one, your company can just take this and copy it and post it on their walls and put it in their AODA policy statement handbook, and you will be at least compliant with respect to the statement. So AODA policies and this policy book must have an accessibility training policy. So how do we train all of our employees to understand their obligations? We have to have a policy around the use of adaptive devices and service animals and support persons. So do we allow service animals in our building? Where do they come? Do we allow support people to accommodate people and to be guides or assistants to people when they come into our organization? Notice of temporary disruption. What's our policy when the elevator is broken? Do we have a feedback process for people with disabilities for them to give us feedback when they're not feel like they're not being accommodated well? And we have to have a notice and format of availability of documents. So we have to be able to say to people, this is where you find the documents. This is how you get the documents in Braille. This is how you read the documents if you've got hearing disabilities. Here's how you click on the audio thing so that it can read it to you. So these are the 5 aspects of what a policy must include. Diversity and why it matters. Well, I've really talked about that. Employers in all sectors of the Canadian economy are now more than ever focused on attracting and training a diverse workforce because our customers are diverse, because the people we need to hire are diverse, because the problems and the issues that we need to deal with are global, because they come from and it can be understood by different people in different ways, because we have hundreds of languages that people speak. And sometimes words mean different things. I listened to a comedian the other day talking about, his difficulty in understanding how the word ass is used in English language, that it's got like 200 different meanings when it's hyphenated and put together with other words. And so, these are, in order for us to be able to understand young people, old people, people from different cultures, people from different countries, people with different backgrounds, we need to have diversity in our workforce. And those that have figured out a way to proactively create diversity are the people that are going to succeed. So we've talked about equity for all. We talked about human rights legislation today, employment standards legislation, employment equity legislation, and AODA legislation. Of course, these all fall out of the Canadian Charter of Rights and Freedoms. And that now leads us to the next part of the Charter, which talks about an individual's rights to privacy. So this one is interesting. Sorry, I'm just going to take a look at our time here. 3:17. We're going to try to be finished here in 30 minutes. I promised you 15 minutes early today to be finished, hopefully even before that. Privacy is a fundamental right for people to have their information kept private. The federal government has established the Personal Information Protection Electronics Document Act, PIPEDA. And basically what the federal government has said is, look, we've got an obligation federally to protect people's information and their electronic documents. We're going to enshrine this into the law, but we understand that many provinces may want to have their own, that they might want to write their own legislation and not rely upon the federal legislation. So basically the law says that here's this PIPEDA legislation written for federally regulated companies and federally regulated industries, and that it'll apply to all the federal government and federal government organizations. But a province is welcome to come along and write their own legislation. And so long as it is fundamentally similar as the original PIPEDA Act for federal government employees. And if a province chooses to not write their own, then this one will apply in the provinces. And many of the provinces have decided that they will go ahead and write their own. And in Ontario, for example, Ontario decided it wasn't going to write its own, but it would write its own with respect to health documents. They felt that they really wanted to, because of the importance of health and because of the fact that health services are provincially regulated, that they were going to write their own act with respect to health information. So PIPEDA protects personal information in the hands of private sector organization and accompanies with those with guidelines for the collection, the use, the disclosure of that information for commercial activity. So we'll talk about this for a second. Well, first off, it applies to private sector organizations across Canada that collect or use this personal, private, or electronic information as a course of their commercial activity. And it gives you a definition of commercial activity, which can include everything from a charitable organization all the way through to, leasing memberships, blood donors, you name it. So British Columbia, Alberta, and Quebec decided that they would write their own privacy legislation and opt out of the federal PIPEDA. So you can bet your sweet hippie that if you read their privacy legislation, except for they have their own privacy commissioner and they have their own lingo and language, that it deals with all of the exact same principles as the federal legislation. Organizations subject to substantially similar to provincial legislations are generally exempt from federal PIPEDA. So the provinces that the provinces have done this don't have to worry about the provincial legislation. With respect to the collection, use, and disclosure. So Ontario, New Brunswick, Nova Scotia, and Newfoundland, Labrador have adopted substantially similar regulatory for the collection and use of personal health, which I talked to you about. So Ontario was the example I gave you earlier, but you can see these other 5 provinces have also jumped on board. So like we talked about with human rights, federal and provincial human rights laws, like we talked about yesterday with employment standards, federal employment standards, each province having their own provincial employment standards. In PIPEDA legislation, we've got the Information and Privacy Commissioner of Ontario. I'm giving Ontario as an example here. We've got the Information and Privacy Commissioner of Ontario, and they have got the Freedom of Information and Protection of Privacy Act, which applies to government-run organizations. So it applies to any government organization, tax collectors, anything license, automobile license, any government organization, the Freedom of Information and Protection of Privacy Act applies to them. If you're in the private sector, they didn't write something specific because they said, nope, federal PIPEDA is good enough, pretty much says what it needs to say, federal PIPEDA is fine. But when it came to their own employees in their own government, they wrote their own Privacy Protection Act because under the Information Privacy Commissioner, they wanted to be able to know and say exactly what information they were obligated to provide when people make an access to information and what information they were going to protect. So, for example, in Ontario, for whatever reason, court decisions, battles, I don't know, they came up with the Sunshine List. So if you Google Ontario Sunshine List 2021, or maybe 22 is published, you can find every single provincial government employee who earned $100,000 a year or more, and they'll tell you how much money they made. So for whatever reason, they felt that the disclosure of information of people earning a lot more money was something that they're going to get asked for all the time anyways. And people, they've proven that through access to information, people have the right to get that information. So instead of having 100,000 access to information by news organizations, and every time somebody does something, some news organization is going to say, yeah, but how much does that person make so that they can write a story about them? Just publish the darn information. And as a matter of fact, there's so many people that earn over $100,000 a year, your name gets buried in there. So it's kind of like better than worse that, they just bury you in information. So the Information and Privacy Commission of Ontario decided that they were going to write their own Freedom of Information and Protection of Privacy Act, which says not only what information are they going to protect, but also what information was accessible for access to information requests. Then they came up with the Municipal Freedom of Information Act, which is pretty much the same as provincial. And they said, okay, cities and municipalities, you're going to have to abide by the same or similar rules. So you have to protect who got a ticket and who didn't get a ticket, and what tax you charge to people for their property tax. They put it into the Municipality Freedom of Information Act, and the Ontario government passed the law and requires each city or municipality. And then, of course, they came up with the Personal Health Information Protection Act, which really provides a lot of protection for people to not be, to protect the information that they hold about people's health privacy. So there's 10 principles to all of these acts. Now, remember, they're pretty much all the same. Federal Act, covering all federal government employees in all federally regulated industries. Each province's act, if they wrote their own act. Each private sector companies in the provinces, if they didn't write their own act, apply to the federal act. Provinces write their own privacy legislation that apply to their own employees. Then they write their own act that apply to the municipalities, holding cities and towns accountable for offering privacy and just telling them what information was allowed to be accessed, to be given out. And then finally, an extra super special high level of privacy around people's personal health information. And the 10 principles apply to all of these acts, which is accountability. So that people have to explain how this information is going to be used, and why the information is important, and having a process and people, so this makes them accountable. They have to identify, each organization must identify the purpose for which they are collecting information. So you need to say, I'm collecting this information from you, this resume from you, which includes this stuff, because I'm going to try to help you find a job. We're going to introduce you to employers and possibly consider you for employment in our temporary help company. So identifying why you're collecting this information. Need to get consent from people to use the information for that purpose. And implied consent is not a real thing. You can't say, if you don't complain about it in the next 30 days, then you've given us consent to use this information. You have to ask for consent to use the information for that purpose. We're going to limit the collection of information to only the information that is useful for the purpose. Now, us in recruitment, like, what information is not relevant, other than stuff protected under prohibited grounds? What information is not relevant? I mean, so we want to know where they live. We want to know where they went to school. We want to know what degrees they have. Eventually, we need to know what their social insurance numbers are and their email addresses and so on. So there becomes, but we need to limit the information to only the information that is relevant to the purpose that we've identified. And then we have to limit the use of the information. So now that we've got the information, we have to have a policy and practices in place to ensure that now that we have the information, that it only gets used for the purposes of what it was collected. I'll give you an example. We owned a business, we tried to sell it. The new buyers said, we'd like to have all the information from all your old customers. And we said, no, like all of our old customers gave us information all along the way about the service that we would provide to them. And if I give you all of my old customer files about the service, we were selling assets. If all the service we provide them, they no longer need or require that service. I'm giving you information. And they said, yeah, but we want it so that we can market to them. Yeah, but they didn't give us the information for the purpose of being marketed in the future by somebody else. So the information was given to us so that we could provide a service to them. Once we fulfilled that service, we didn't need the information anymore. If they were going to keep coming back every 6 months, we'd want to keep having it. But I mean, this is the healthcare business. A lot of those people are no longer alive. So the new buyer wanted to have all that old information so that they could start email marketing to their families. The information was provided for a purpose, which was provide a service to a person. We cannot use that information and sell it to a buyer who wants to use that information for solicitation purposes. So this is the whole controversy often about Facebook and social media, that they start to collect algorithms on what we like and what we don't like and how old we are and where we live. And then they start to figure out what's the average price of a home in that area and what is the average age of people living in that area. And the next thing you know, Facebook has all of this information, and then they can't disclose it to another organization or sell it to another organization so that they can use it for marketing purposes. And so we're constantly clicking in social media saying, yes, you can collect my cookie. Yes, you can collect my data. Yes, you can customize my marketing. We're constantly giving specific permission to people because they're going to be collecting information, but they're only allowed to use that information for the purpose of which it was collected in the first place. So on the contrary of that, number 5 means that we have to also promise that we're going to limit the use of that information to just the purpose that it was collected. We have to ensure that the information is accurate as possible. So if a person contacts you and says, hey, that information is no longer accurate, I don't live there anymore, we've got an obligation to remove the old information from the file, or to say that in the file that information is no longer accurate, but we've got an obligation to ensure that it's accurate and to not be using inaccurate information. We've got an obligation to safeguard the information. And we need to show in our policies that the information is protected. So this is why when we have a breach of security and somebody hacks an online site and somebody hacks a retailer and gets their customer list, or someone hacks a dating site and finds out all the married people who have been on the dating site or something, that they become so new, not besides the fact it's offensive and concerning that somebody's got your information, it's also just a pure violation of the law, because these organizations, when collected the information, they had an obligation to provide safeguards to that information so that they couldn't be hacked. Now, at the end of the day, not too many companies are being charged with violations of PIPEDA after they've been hacked, unless, of course, they've proven 2 things. That either 1, they were negligent in the manner which they protected the information, 3 things. 2, they did something and used the information in a manner for which it was not intended, which might have led to the breach or the disclosure of that information. Or number 3, openness, that they never disclosed to people and they hid from people that they were breached, that the information did leak. So there's a whole bunch of obligations, particularly, so example, in Ontario, when I bid on a contract to deal with a hospital, I have to fill out all pages of what our policy is if somebody loses a record, a file, or laptop, or a phone. And they want to know that we have got very documented process on how we deal with it from an openness standpoint, and what we do to safeguard it, and how we react to it afterwards. So number 7 has to deal with safeguarding the information. Number 8 has to do with openness, which is honesty and transparency about what happened to the information and about what information we do have and what it might have happened if it leaked out. We need to give individuals access to their own information so that they can update it, erase it, remove it, ask for it to be removed, or change it. And then we've have to have a policy in place for people can challenge you with respect to your compliance to the laws. So what information would be considered personal? Forget health information. It's very specific, and health information is health information. We're talking about medications and health card numbers and health concerns and visits to the doctors. I think, pretty much everything that's got anything to do with health has got to do with health. And so that's how. But in the general context of employment and service providing and customers, we've got age, name, any kind of ID number, which might be a social insurance number or a driver's license number, or something, what a person's income is, what their ethnic origins might be. You might have collected information under employment equity program, and it's over there in that employment equity file. It's got ethnic origin, things like blood types, that's health, religion, that would all be considered private. Your opinions that you might have expressed at work or in your customers, if you provided opinions about the service you provided, those all must be accumulated and kept private, and they can be put together in accumulated format. You can say 70% of people are super happy, but you can't say, but Johnny complained about this. That information cannot be disclosed. It was not collected for the purposes of Johnny's disclosure. Of course, if Johnny wants to go onto your website and file a complaint in an open public forum so that everybody can see it and participate in the discussion, that's up to Johnny. People's social status, any disciplinary actions that might have promotions or demotions or suspensions or bad employment reports, all of those things need to be protected. Employees' files, their credit information, their credit cards, their loans, their medical records, any disputes that they might have had, any complaints they've made in the past, those about their privacy, the intentions of people to change a job within or without the company, or filing of human rights complaints. These are all things. So if a candidate says to you, yeah, I'm thinking about leaving my job next year, it's your obligation to keep that private. You can use it for the purpose of which it was intended, which is to time the assistance of helping that other person find a job. But you can't disclose that information in a way, say, to their current employer or to somebody else who might use that information in a deleterious or harmful fashion. Your province has adopted another privacy legislation, and therefore PIPEDA does not apply within that province. Well, the answer is true, except for the federally regulated organizations like transportation companies, radio and television communications, telephone companies, the federally regulated ones, they still apply to the federal PIPEDA legislation. So it's true. These are all falso. These are all falso. These are all trick questions. So it's true except for when. One of these things does not belong. Which of these following statements about consent is false? Organizations can generally rely upon implied consent when the information is likely to be considered sensitive. False. I already told you earlier, you cannot have implied consent. You either give consent or you don't give consent. And so not consenting to use somebody's information means don't use it. The consent mechanism chosen should be clear and ambiguous. Yes, it is. The consent can be obtained in a number of different ways, such as in person, by phone, via the internet. Yes, consent can be given in many ways. You know, there's all kinds of things, like, for example, um, when I'm giving consent to, I can't remember. I think it was a telephone company, when I was changing some information about my internet and my payment method. They said, this portion of the call will be recorded for the purposes of recording your consent. Hot water tank rental. I needed to get a new hot water tank rental. They weren't going to send me a form. They weren't going to send me a PDF. They were going to mail me something. They said, in this portion of the telephone conversation, we need your consent to record the conversation. It's important for us that we record also your consent to the purchase or the lease of the new, and to collect your credit card information. So they turn on the recording. They say, do you understand that? Yes, I do. Yes. Do you know that we will be using this information for the purpose of only for billing for the water tank? Yes. Do you understand? Yes. And they go, great. Poof, they stop recording. So consent can be collected in many ways, except for implied consent, which is, if you don't tell us by Friday, we'll bill you. Or if you don't tell us by Friday, we'll assume you're allowing us to use your information. When you make a complaint through the privacy, what you do is you make your complaint to the organization in itself. And each organization has an identified privacy officer. The privacy officer is not supposed to disclose the complaint to other people. The privacy officer is supposed to deal with it through the privacy office. And hopefully your complaint about my information is incorrect, or my information leaked, or my information is, I need to review my information, or you guys are using my information in the wrong manner, that complaint can be resolved there. If you do not solve your complaint through the organization's compliance officer, they go to the Office of Privacy Commissioner of Canada. And of course, if you're a provincial organization with provincially employed people, then you would go to the provincial officer. Go to the provincial officer of Canada, and that officer tries to get an early resolution that occurs back here. They don't want to go to court. They don't want to get findings. They don't want to do all the stuff. They don't want to issue fees. They want people to resolve their issues. Now, of course, if you didn't have a policy, if you didn't have a place, if you used the information in a manner for which it was not intended, if you were negligent in the manner in which you protected that information, so on and so forth. If you didn't comply with the principles of the privacy, and you did that in a negligent or intentional manner, then there can be fines, and the Privacy Officer Commissioner of Canada would intervene with those charges. But most of the time they get an early resolution officer who comes in here between the complainant and the complainer, and they try to get people to resolve their issues. We could talk ad nauseum about social media and about what information you're allowed to collect, what you can expect of your employees in putting information out there in the public domain. I think that that's an entirely another 1 hour workshop on social media and social media policies, and how that can affect privacy, but it also affects other things, just contractual employment, contractual things. And we can also talk forever about COVID-19, about collecting information about people's vaccine certificates, and about their vaccine status, and providing information about whether or not their kids are sick at home, and whether or not they've had exposures to people. These are all health, personal private health information. And I think that generally, with respect to that, we're going to find, because there's going to be more civil suits. I mentioned to you yesterday or today that there's already been one civil suit in British Columbia, the first one in Canada, about a person who was suspended, temporarily suspended, because they didn't have their vaccinations in a mandatory vaccine policy environment. And That there's been one civil suit on it so far, and you got to bet there's going to be more, right? And when there's more, the question is going to arise: was did the organization, did the company have the right to ask you in the first place? And I think the answer to that's going to be yes. That we had the right to ask somebody, have you been infected? Have you been vaccinated? You know, I mean, the federal government already established you can't come across the borders, you can't drive, truck, you can't go to work. They had all kinds of policies around that. You can't go to certain places, you got to close down industries. So the first question is going to be, did they have the right to ask it? The second one is going to be, did you collect and keep that information? The next is going to be, how did you use that information? And has that information been used in a manner for which it was not intended in the first place? And now, and maybe if the information is no longer required, have you disposed of it, cleaned of it, or put it away in a place so that it cannot be used in the future in a manner for which it was not intended? Okay, guys, I did it. I came in 15 minutes, 16 minutes early. I'm going to flip off of, I don't think that's good. That doesn't sound like good. Flip off. I'm going to come out of the share screen mode and stop sharing, and we'll come back into this mode. Please, if you want, please unmute, come back on video. Let's spend the last couple minutes dealing with any questions or comments or feedback from people who are there today. Nobody's being bold. I've put you all to sleep. Okay, so this is the way I want to close this out today. The things that we talked about today: human rights legislation, employment equity, AODA, equity, and finally privacy. These are principles that, in my opinion, I believe that if you make them part of your organizational mantra, part of your culture, not just your obligation and understanding under the law, but the things that you believe in, that you believe that people with disabilities have got so much to offer with the abilities that they do have, that you believe that people from different places around the world who speak different languages with different cultures that look differently and have different religions can bring so much to your organization by helping you to understand how to serve your community, how to be better service providers, how to be more flexible, that you will have access to a larger workforce, more in a declining workforce where people are hard to find, that if your organization can adopt these philosophies as part of your culture and your beliefs, that you will have more workers, you will have higher retention, you will have lower costs, you will get more customers, you will keep customers, you will be more profitable. And so it doesn't just need to be something that you feel in your heart that fits your personal beliefs. It can be, this is good for business. It can be because you think that it's important that all people are treated with decency and respect and equality. And it can also be because it'll make you more money and more successful, and that it'll help you to employ more people and sustain your business for a longer period of time and have fewer troubles and more successes. I've been talking about this and I've believed this since the day I entered this industry in 1983, and I feel more and more strongly about it today. I also believe that due to social media and the internet and television and all of the communication mechanisms that we have available, that people with belief systems that are not about the integrity of equality are emboldened to say things and act in offensive ways that they didn't act in 10 years ago. 10 years ago, if someone was a racist or discriminatory, they tried to hide it. And we're now today shocked. It's shocking to see the number of people that think it's okay to act like it's cool to be discriminatory or to have strong, overt opinions about people that are different. And, can you mention certain politicians that maybe have been public, very popular in the United States, for example? And, we take a look at this and we got to ask ourselves, why did this happen? And it happened because those of us that believe in this, that believe that equality, integrity, and respect and decency and opportunity to people, that when we believe that this is good for business and good for our culture and good for our organizations and good for our own personal mental health and for our families, that when we believe in this, we're kind of quiet. It's kind of like our own personal belief. And that crazy people who have got really overt offensive opinions about discrimination are unashamed to express their opinions. And so they use social media and they use the vehicles that are available to get their opinions out to the masses. And because none of us speak up, it becomes more popular, or at least other people think, well, my goodness, that must be like a common belief, when it's not, when the vast majority of us think differently. So listen, I've been successful in this business. I grew a business where at one point in time, I had over 400 active desks of recruiters working in our company, 7,000 temps and contractors working every day, 25,000 T4s to contractors and temps at the end of the year, thousands of perm placements, 700-800 active customers at a time. I've been successful in this business. And I believe that I was successful in this business because I was outspoken about how important these principles are, about how they define the culture of your organization. And our hope at ACSESS is that everyone who becomes an ACSESS member, and that every single person who becomes and acquires their CPC will take these courses and will talk amongst each other and will understand not only the laws and their obligations, but the opportunities that exist as a result of adopting these in an overt, open, demonstrative way. Because it looks good on you, it looks good on your company, it looks good on your industry, it serves you, it serves your success. And so own it. Own it. I know that a lot of what we talked about today was just technical mumbo jumbo. Here's a law, here's how it works, here's the word, here's bona fide occupational requirement. But behind that are principles that matter. Live those principles and you will be successful. I promise you. Okay, guys, have a great day. Thank you very much for joining me and allowing me to kind of pontificate for the last 5 or 6 minutes of the presentation. Good luck in your CPCs, and I hope that I will see you again, because I do facilitate some of the other sessions. I hope I'll see you again sometime in the real near future. Have a great day and a great weekend, and happy Thanksgiving.